to Legally Speaking with me, Tarun Nangia. Very, very important judgment upholding constitutional rights passed by the Supreme Court. The grounds of arrest in writing must be given uh, 2 hours before arresting a person and also to his relatives so that he can arrange for adequate defense and lawyers. If you take the business and the promoter community in mind, we see that they are fearful to go even for questioning because they feel they may be arrested on the pretext of questioning. And that is why we discuss this today. And it has a chilling effect on the business community if such thing happens. And at such a time, this order of the Supreme Court has come. It is indeed something that we shall cherish because the Supreme Court understands the wider ramifications of arrests on investment in India and business in India. It's not just a matter of arresting a person. I have with me somebody who was greatly praised for the Satyendra Kumar until judgment, Justice Sanjay Kishan Kaul, who also served as a member of the Collegium of the Supreme Court. Good to see you, sir. Thank you for your time.
Thank you.
I have with me uh, Advocate Amit Nayak, who joins us from the city of Mumbai. He's managing partner of law firm Nayak and Nayak, a firm that deals with these day in and day out. And we have with us Advocate Sri Venkatesh, who argues at the Supreme Court of India and the Delhi High Court, also a lot adapted. Good to see you, and thank you for your time. At the
Thank you.
outset, let me request Amit to lay down the ground before we move ahead. Over to you, Amit, for your opening comment.
So, first of all, it's an extreme honor and privilege to have this audience with Justice Kaul. I've been a great admirer of his judgments and appeared before him several times. Thank you, Venkatesh, for being there, and Tarun. So, let me say this, that the corporate community in general in India lives under fear. I think every time there is an investigation, and we know the rigors of the PMLA, we know the rigors of what happens with SFIO, I think the Indian promoter is scared to sit on the board. I think that's the subliminal sort of subtext, I would think. I don't think it's subliminal. I think it's out there that today an Indian promoter who really nurtures the company is sort of accountable. Now the question really is this: I think a time has come, and I must say this with a sense of responsibility that I've practiced the length and breadth of the country. Courts, despite the dictate of the Supreme Court, are reluctant to grant bail. I think the lower judiciary, including our high courts, are very reluctant. Bail matters don't reach. I was in court today. Matters don't reach. We have families waiting. So I think this is a sort of situation that we have to deal with on a daily basis. Now, coming to grounds of arrest, I must say this, like I've had the benefit of working with Mr. Desai, Mr. Ponda, all of in Bombay. We have time and again raised grounds of illegal arrest. And again, it often it becomes a sideshow. And I think this judgment is welcome in terms of its timing, in terms of what constitutional rights are. And I think that's the most important thing, Tarun. I would think it's upholding constitutional rights, which is very important. And I think that's the messaging that is important across the length and breadth of the country. I'll sort of pause here for a moment. Thank you. Oops.
Thank you for that opening comment. I'll go to Advocate Sri Venkatesh for his opening comment on this judgment.
Thank you, Tarun. In our Constitution, Article 22, 1 already says that a person who's been detained for any offense is required to be given the reasons for his detention or for his arrest. Now, the question in this judgment really was that while in certain special laws, the Honorable Supreme Court had ruled upon that the grounds for arrest must be provided to the accused. But the question in this matter was that should that be made applicable to all laws prevalent in India, irrespective whether the arrest is being carried out under the new criminal code or under any special enactment. Now, the Honorable Supreme Court traced the law on this subject right from the very first few judgments which interpreted Article 22(1), and then went on to say that look, since all laws are subservient to the Constitution, and if the Constitution itself provides that grounds of arrest are to be made available to a person who's been taken under detention, therefore it must be that irrespective of which law is made applicable, which offense is made applicable, you are to provide these grounds of arrest. The only exception now is that if you can't provide those grounds of arrest at the time when the detention is taking place because for some exigency, then you have to at least provide him 2 hours before he appears before the magistrate, so that the accused as well as his family members can understand under which provision of law for what offense they are being arrested, and accordingly take mitigative steps to at least prepare their defense or even apply for bail. I mean, post-arrest bail. This is something which, gets unnecessarily delayed if the grounds of arrest are being denied to an accused for a number of days. So that's really the scope of it. Now, coming to the implication of the judgment on let's say, on the corporate India, I find that, there are some of these offenses under the Environment Protection Act as well as the Water Act and Air Act are all, non-bailable offenses. So if just because a director, you're sitting on the board of a company and there is an offense, something has happened at your plant site which where you have no active or passive role to play in terms of what has really taken place. You are suddenly put in the in the eye of the storm, and you are being arrested for something that you're not even aware of. So in such situations, if the grounds of arrest are made available to the accused at the time when the detention is taken place, then he can very easily chalk out his way forward in terms of legal strategy or in terms of representation, because some of these offenses are, some of these FIRs are very, done very pedantically without understanding who's in active and passive control of that particular, event. Therefore, this is, I think, it's a step in the right direction. I think the Honorable Supreme Court has clarified that no law can, claim any exception to this rule. The rule has been there in the Constitution. It must be followed in letter and in spirit.
Thank you. Thank you for that opening comment. It is said that once the lawyers have argued, the judge has the last word. And Justice Kaul, I may want to remind you, when I did a series of shows upon your retirement, a lot of lawyers came up with this point that on grounds of liberty, we were assured that this is one court where we would get a hearing. And it was very heartening to note that this message came from across the bar. And when you see that such judgments are now being passed by Justice Gawai and Justice Augustine George Massey, now wanting to, they are also saying that this should be given in the language that the family of the person arrested understands, the notice on the grounds of arrest. What is your feeling? Because you have also been a great libertarian when at the Supreme Court. Could you give me a longish answer detailing what the Supreme Court is doing, what message is being sent across, and will there be any problems in implementing this?
So let me first thank you for all the compliments. For a retired judge, it is very heartening to note if a bar respects what you have done. Ultimately, that's the only brownie points we carry forward in our retirement. I've held the view that, we have slowly structured into a scenario where earlier you had this bail was the rule, jail was an exception to jail being the rule. The justification which was often given for this was that, well, economic offenses stand in a different category. When they were talking about bail being the rule, you were talking about the not so affluent section of society. And in this section of society, it's the more learned people, educated people who are involved, and they damage not a single person but a whole establishment. That is the philosophy why slowly a change started taking place in this. But it had to have its limitations. And we can't have a scenario which I feel is that let's keep this person behind bars as long as possible. That is his punishment. Whether we ultimately get a conviction or not becomes immaterial, but the period undergone is treated as some element of punishment, whether we succeed or not. Now, that philosophy has a great flaw in it. The endeavor which we made earlier, sitting in the court, was with Antil's judgment. It's not that something new was being done. It was just consolidating the views which the court has taken over a period of time and issuing a guidance to the courts in the high courts and the courts below. And Justice Sundaresh, who was the author of the judgment, did an excellent job of it sitting with me. So we sent a signal, but even after those signals were sent, we realized that there were many breaches which used to occur. So when you're talking about what issues is, apart from until we dealt with a scenario also where in some of the states they would say that if even if you are not detained during investigation, when investigation is complete and a charge sheet has to be filed, you must mandatorily be arrested and produced. This is not the police view, this is also the court's view, the trial court's view. So we have to say, look, this is not required. Where did this law come from? You file the charge sheet. If somebody doesn't ultimately appear in pursuance to a summons issued, the issue of non-bailable warrant would arise. So there have been different breaches in different places for it. It took us some effort to try to instill that this judgment has to be followed even then. And I tell you, this is a continuing effort to my mind. It cannot be that A person does it and he's no more, so a B person does it. It must be a continuing effort to instill in the people. In 2023, as head of the NALSA, we had a conference, the annual conference, and in a closed door meeting with the senior J1 and J2, which are parties in NALSA, I very explicitly said this. See, earlier we used to feel the trial court is passing on this burden of bail to the High Court. Now, don't do this to us, because every day Supreme Court is seized of, every bench is seized of 5 to 10 cases for bail. The problem is not only that these bail cases are coming, but on a personal note, I found myself interfering in almost one third of the matters, which is a very large number to interfere. And this is in the context of somebody like Justice Chalmeshwar, whom I sat with, who said, don't make it into a bail court, that improve the situation in the High Court. But the fact is, personal liberty being involved, if a person comes and you feel that actually just for the asking it should have been granted, there is little option but to intervene in this. I think this judgment now does a salutary service in terms of fixing a time which is important. See, when we say that the grounds of detention should be uh, given, urgently given, may not be at the same stage of time. The significance of this government, while it traverses the path of Article 21 and 22, and then goes into the provisions of the new Act under 497, 498, are that provisions are there, they must be followed, but followed in a timeline methodology. So you say that at least 2 hours before he is produced, they must be available. Now, 2 hours before availability has a significance. As you said, the significance is the family members also come to know what is being put against the person. And at least some time, may not be adequate time, but some time for the lawyer to have a look and see what is happening and at least give a first presentation of it. The second limb, which I feel is important in this judgment, is that a consequence is also provided. So, if you don't do this, what happens? Otherwise, it's a breach. Now, what happens next if the breach is there? That breach will arise when, if the time is not there, they say the proceedings initiated are not correct or they need to be quashed. That is what I think is a significant part of it.
What I have seen is that when a bail is sort of order comes out from the court, the ramifications of that bail on the business community are something which sometimes even the court may not understand, because the kind of discussion that goes in promoter groups is huge.
Yes.
And also, many times Indian promoters are signatories who sign checks of release of payments themselves, because India is mainly a family business driven economy. You throw the main person in jail, the whole business collapses, salaries may not be paid. Sometimes you don't even understand the implications of how wide these implications can be. Case in point is some people where the promoter has been arrested, the children have taken foreign citizenship. This is a very big thing because they may not invest further in the country. So that's why liberty has an economic angle. I'll get Amit in at this point to take his view on the complex nature of law and courts not just being not just being, just a matter of bail, but if it is delayed for months and then years, it has a ripple effect. Could you reflect on that aspect? And then what the court did, do you think it is easier said than implemented, or do you think this will be implemented in letter and spirit from now on?
So I only hope that it will be implemented, because I would think and reckon that that's the spirit of this judgment, and it's, like I said, it's right timing. Tarun, the point that you made, and what Venkatesh also said, Look, we have Mitta's case, we have Mukesh Ambani's case, everything in terms of vicarious liability under criminal jurisprudence, etc., particularly of directors and key management personnel, KMPs as we call them. See, the challenge really is this today in corporate India, that corporate governance requires key people to be involved in terms of decision making. Now, the question is, I think there is a clear distinction in what is an executive director and a non-executive director. Tarun, I think there's a lot of jurisprudence on this. Unfortunately, many of our courts, and I must say this with a sense of responsibility, do not understand the subtle distinction between an executive and a non-executive director. And I think that's where the penny drops. Because please understand, a chairman and a managing director is not responsible on day-to-day management. How is he accountable for, like what Venkatesh rightly said, under statutes like Environmental Protection Act, under Foods and Safety Act? The question today is, are they involved with day-to-day management? Now, coming to this judgment, I think this judgment is a judgment for every common person and families of common person, because let me tell you, when an arrest is made, and again, I'm saying this with a sense of responsibility. Agencies are not communicating to the relatives because it's done. And I'm not saying all. Most of our agencies are responsible, but the relatives who suffer, grounds and communication. So I think the takeaways of the judgment are it upholds 22(1), which is a complete constitutional right. I think it's made things crystal clear in terms of communication, at least in terms of timing. And I think you couldn't have had it better and clearer. I think Pankaj Bansal's case also there was history, etc., and what his lordships were saying right now. But the point really is this: for corporate India, even when an arrest is the last thing that can happen. And if a ground of arrest is not communicated, in point of time when you're in the trial court, you want to challenge the illegality of arrest. And I'm telling you, it is almost like it's the most important thing that you would argue in a matter, more than the merits of a matter. So I think this is a great judgment. Kudos to the Supreme Court for looking at this in terms of timing. And I think, this is there to stay, Tarun. And I think the communication is large, at least to our courts below.
Thank you, Amit, for this insight into the issue on chairman, managing director, non-executive director, and directors. Very relevant. I think this needs to be highlighted more. I'll go to Advocate Sri Venkatesh for his intervention on the whole ecosystem and how this impacts business and the Supreme Court judgment by Justice A.M. Masih and Justice Bhushan Gavai.
So, Tarun, the example that I took actually is a real example. And I think one of these power plants which are owned somewhere in Gujarat, somebody filed a complaint before the pollution board. In the complaint, he made all the directors of the company as parties and as well as the independent directors of the large conglomerate as a party. As a consequence of that complaint, an FIR was registered, and two people showed up at the residence of the independent director who happened to live somewhere in Gujarat. Now that was the case. Now, of course, for that particular case, since we already had the copy of the original complaint, we could rush to the High Court and seek some kind of an interim protection. But imagine a situation where an independent director gets picked up for an offense or an allegation, and he does not know what is he getting picked up for. So I think what the judgment is trying to achieve, and rightly, I mean, the law is trying to achieve, and the judgment is trying to enforce, that you must individualize the offense with the person who you're seeking to arrest. That mile has to be walked at that path has to be walked at some point in time, which earlier was getting missed out in the large offenses which are being where the parties are being picked up by the police or the investigating authority. So therefore, the moment you have to bridge that gap, that gives the person who is under the scanner the opportunity to defend himself and say, look, if the offense is this, and if you're arresting me for this offense, my defense is this. And that is something which sort of was delayed in these criminal proceedings time and time again, even though the Honorable Supreme Court in several judgments said that the grounds of arrest are if not provided to you, the detention is illegal. Now, what this judgment does is in addition to saying that, yes, this is a mandatory procedure, you must provide the grounds of arrest at least 2 hours before the accused is presented before the magistrate. If you don't do, the converse is that the arrest is illegal, the detention is illegal. And therefore, an opportunity is given to every individual, even if it is not followed in letter and spirit in every police station and every officer across the length and breadth of the country. At least since the law has been declared by the Supreme Court, the accused will have the opportunity of relying upon this judgment and seeking relief from an appropriate forum, saying that, look, I have not been given why I'm being arrested, and therefore I need to go out. So therefore, this individualization of the person who's being arrested with the offense is really the intent of this judgment. And I firmly believe that this is completely in the right direction. And I hope and pray that, investigating authorities and as well as magistrates are looking at these trials, look at this judgment in the seriousness it deserves, and accordingly grant relief in cases where such salutary procedures are not being followed. I think there's a very interesting passage. It says that this is not a procedural safeguard; it is a constitutional protection which is being affirmed to the citizens of the country. That the judgment records that in one of the passages, which is, I think, a very interesting way of putting what this judgment really means.
Thank you for sharing. Indeed, it's a constitutional upholding the constitutional rights of an individual. I'll go to Justice Call. At this point, one top counsel of the country once told me that I don't argue this court because this is a no bail court. You argue whatever in the world, we know what the order is. So when he told me this, I said, isn't this a worry? He says it is. Even if there is a 50-50 chance, I may still go. But if you know the order before you even opened your argument, then why should I waste my time? It is a tragedy when such things happen, when people know what order is going to come. And sometimes you may not want to believe it, but when you see the order, you realize what he was saying is the truth. And mind you, this is one of the country's top councils opining this. Do you think there the judiciary should also reflect in light of these orders that are being given now, the one that is given by Justice Bhushan Gawai and Justice Augustine George Massey?
Okay, on the little lighter side, when I joined the law faculty, there was a little joke around that one of the people used to teach us, his thesis began with in the Supreme Courts of India. So, we used to take it on the lighter side. So I say when I reached the Supreme Court, I realized how true he was. We don't have a Supreme Court in that sense. It's not a collective court sitting like the US court. So there are Supreme Courts of India. That is why a lot of litigation generates depending on which bench you are in. But it is also the duty of the Supreme Court to see that there is a broad consistency in approach which has to be adopted. It can't be, everybody can't wield his sword in his own way, is how I look at it. Sometimes we may be fully inclined not there, but yet there is a law laid down. So 136 cannot be used, in my respectful view, in this manner where you create an uncertainty and therefore a lot of litigation gets generated in the Supreme Court because people are not sure where the whole thing will go. See, what is important is I had the judgment before me, and one aspect which was pointed out was giving it a constitutional structure. Very important. Number two is para 56 subclause 3 says that the said grounds to be communicated in writing within a reasonable time. That reasonable time then is defined, and in any case, at least 2 hours prior to production of arrest for remand proceeding before the magistrate. So it has been defined what the law is required to do. Importantly, clause 4 of that para 56 says, in case of non-compliance of the above, the arrest and subsequent remand would be rendered illegal and the person will be at liberty to be set free. So the consequence of violating this norm is that the person has to be set free. You can thus enforce this judgment in whichever area there is a breach. I'm not saying breaches will not occur. My experience is they will still occur. There will be many reasons. Government will oppose it. But you have this opportunity to come to court and say, look, this is actually a violation of this judgment. And if you violate this judgment, then please set me free and let's hear it. Ex officio, has it been handed over 2 hours before or not? If it is not, I must be set free first. Then let's talk about anything else. And I'm sure that this kind of a thing being put even on the subordinate courts or the high courts, they will recognize the salutary effect of this. I would say the hands are strengthened by the law laid down by the Supreme Court, which says that the breach of this 2 hours norm prior to production in court being breached, the consequence is please set him free. So I think that's the significance of what is being achieved by this. Everything takes time to seep down and do so. So let's not be discouraged by the fact that there will be some breaches. Of course, there are. After until also this happened, but the courts have to keep on pressing. But I think you raised an important issue that the final court and the Supreme Court must do so consistently. If it does so consistently, I think a signal gets sent. And if the signal gets sent to the High Court, that signal will get sent to the district courts too, who are above it. And it's time we do it because this is something which is, I think, troubled all the courts. It's troubled business community. It has troubled the non-business community also. Sometime recognition, starting from a small issue like check bouncing case, they are, someone issued without realizing who has issued the check. I face scenario where independent directors have been issued on a check bouncing case. So these nuances which have to be seen, the courts must understand the nuances. That's a process of education, I think, of how a corporate system works. And I think what the two panelists have pointed out is important is that we want to develop business. We want to inculcate a business culture. While on one hand, violation of law is not something which the business community can treat it as a license, but don't there should not be a terror creation for them, where the very purpose for which the law is created gets affected.
Thank you. Thank you for that intervention. When I hear you, I feel always you've upheld the spirit of law being from justice and not justice for law. And that we saw in all these years and how you conducted yourself and also the
Tarun, intervening, see, law. I feel when we deliver justice, it comes both from law and heart, both. You can't let any one play over the other. You have to go by the law, but there's a heart also which plays its role while dispensing justice. It has to, if we have to dispense justice.
Indeed, well spoken. Now we'll go to a round of closing comments in 30 seconds each. Some good words about this judgment that you feel that this judgment has done for society. We start with Senior Advocate Amit Naik, Managing Partner of Naik.
But I'm just going to say three things. I think, as I said, I think timing, the eloquence of this judgment in terms of upholding constitutional right, I think that's the second point. And the third is, I think it's so simple that everybody now understands that the diktat is very clear, that the communication must be very, very clear and unambiguous. So the smoke screen, according to me, is come to an end.
Thank you. Thank you for that closing comment. Advocate Sri Venkatesh, your closing comment.
Thank you, Arun. Before I give my closing comment, just on Justice Kaul's reference to Supreme Courts of India, I'll give you a very small anecdote. Two of us were before a tribunal fighting against one single party, the state discom. Common judgment delivered. Now, both of us are the two appellants were represented by two different law firms. We both are filed our separate civil appeals. The Honorable Supreme Court listed, because it was the last week before the vacation, somehow listed both the matters in two different courts. One in particular court, the other at an early number, the other one in a later court and a later number. The first matter came up, which was not my matter, mine was a later matter. The bench dismissed the appeal, saying that there is no question of law, we're dismissing it. By the time the lawyer who represented the respondent in particular court rushed to our court, this bench stayed the judgment and admitted the civil appeal. And the order was already dictated. The party came and the lawyer came and shouted, "Look, the one appeal is dismissed, the other one you're admitting." He said, "Nothing doing. I find merit in this case. I'm admitting the civil appeal and I'm staying the order." So this is really, it has happened in front of my eyes, and I'm nowhere near experienced as Justice Kaul. Therefore, I have seen this in the last 16, 17 years happening in Supreme Court. So that's on the anecdote of Supreme Courts of India. And as my closing comment, as I started off by saying, and Justice Kaul rightly read out that passage, that now there is a remedy available to a citizen in case the grounds of arrest as mandated by the Honorable Supreme Court is not provided to the accused. I think that's a very important thing, because a lot of times, the trial court goes beyond the infraction in the legal process and goes to the merit of the matter. Here, there is an exit available to the accuser. Look, I don't know what I'm being arrested for. Therefore, you have to set me free. And you can initiate remand proceedings, but I need to be, taken out of custody. So that is a very important thing, I think, which has come out in paragraph 56.4. And I think accordingly, since it's going to be a law in development, hopefully as this judgment would be relied upon by several high courts and district courts, and hopefully relief would be given to parties where this important constitutional safeguard is not being followed.
Thank you. Thank you for that closing comment. We'll go to Justice Sanjay Kishan Kaul for his last word of the show.
So I think we are not short of cases or case law. In fact, on the other hand, my view is we have too much and outweighed by precedent laws, which creates the judgment writing also bulkier. So what is important is to crystallize the issues. And I think if until did that earlier in one direction, this judgment has clearly done so and succinctly done so. So clear points, 4 points put. You have to disclose the grounds of arrest. You must disclose it early. You must disclose it orally if you're not immediately able to give it in writing, but you must disclose it in writing at least 2 hours prior to production in court. And if you don't do so, the consequence follows that he has to be set at liberty. If you read this clearly, I think this paragraph being set to the district courts and the high courts itself is a binding precedent of the law which has been sketched out in this judgment. And I think that's the important part. I hope that this gives an opportunity, I would say, to the district courts and the High Court to release people following this judgment. One little issue on this is, I also believe another practice which has started, and I think the legal fraternity and the bar has to also do so. Bail matters can't be argued like a final hearing matter. See, you must make out a ground for bail. It doesn't help in arguing for days together. Then the judge writes some 40, 50, 100 pages on bail. Then the Supreme Court faces this, and then one of the parties comes and says, oh, bail has been granted or not granted. But it should not be a precedent. Why does everything else which is not relevant for bail get argued, is my view. Therefore, let the bails be decided in short time. It can only be decided if crisp arguments take place, if crisp judgments come. So lawyers have to argue less, judges have to write less, and we have to come to the conclusion. Then only we'll be able to handle the volume which we face with. Otherwise, this is a problem which continues.
Thank you. Thank you so much. On judges writing less, I think Justice Ramanna had made a long statement, but I think that also has been sort of forgotten now. Maybe we need more reiteration on shorter judgment because we all sort of suffer from those sometimes. But it was indeed a very engaging discussion. Justice Sanjay Kishan Kaul, you made time on this important issue. I was assured that anything concerning liberty, you definitely will give time for. And thank you so much for that.
Thank you.
Amit Naik, Managing Partner of Naik and Naik, thank you so much for joining us. Advocate Sri Venkatesh, you all made time in the interest of liberty. This is also in the interest of India's growth trajectory, investment in India, and growth in jobs and investment. It is not just court cases. Thank you so much. Appreciate you joining us. Thank you.
Thank you.
Thank you.
Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.